Maintenant vers M. McLean pour 4 minutes.
Thank you, Mr. Chair, and thank you for the variety of witnesses here. I'm going to start with Mr. Castrilli because one of the things you said really struck home for me, and that is the fact that we want to deal with the definitions in this legislation as opposed to having this interpreted in courts. And it's something I've said at this committee numerous times as well, and you did give some examples of things that need to be further understood before we just throw them into the courts for discussion at that point in time. But you did go into some detail here on some of the proposed amendments you talked about. You talked about the constitutional effect of dividing the schedule into Schedule 1 and into two classes, Part 1 and 2. And that's, I think, from 2007 Standing Environment Committee report you refer to here. And I'm a bit of a skeptic on that, so I'd like you to enlighten me a little more, please, because if I asked for a constitutional lawyer something, I think I'd get 6 different answers at this point in time, and I really appreciate what you have to say about how we're going to have a different, a constitutional battle. Who are those people that are going to challenge this constitutionally, and what would be the basis of the challenge?
Mr. McLean, thank you very much for the question. I think the best place to start is that, as you may know, there are already 2 challenges to in the federal courts challenging the plastic manufactured items designation proposed, or actually in effect, pending the results of the federal court cases, brought by an industry coalition concerned about that designation. That case was the first of those 2 cases was actually brought a month after Bill C-28, which is the predecessor to Bill S-5, was tabled in the House of Commons or in Parliament generally. So there's necessarily a connection between the 2, although it is the timing is as I've suggested. The basis for their concern, as I understand it from reading the filing, the notice of application, is that the constitutional foundation for SEPA is based on Section 9127 of the Constitution, Act 1867, the criminal law power. And in order to be designated as valid federal legislation based on the criminal law power, you have to have a valid criminal law purpose. And the courts have said essentially that the problem has to be an evil, or it has to be something that is injurious to the public. I take it from the claims in the documents that were filed in federal court. The industry coalitions are suggesting that plastic manufactured items are not injurious to the public. So that's their claim. How that will play out is for the federal courts to sort. What I'm concerned about is
okay. What I was trying to get at here was your argument of constitutionality. Your concern here is on what's already ongoing in the federal court regarding the case around plastics. Is that correct?
Which can be made worse by sloppy drafting, which is what I think Bill S-5 is engaged in. I don't think it was a wise decision to eliminate, for example, the title of Schedule 1 list of toxic substances.
And with respect, so we're, and I'm not a lawyer, I think a few of my colleagues around the table are, but there are other environmental organizations that have provided us with testimony that directly contradicts what you're saying there about the title. And so we're being led in 2 different directions by different environmental organizations here. So can you address the confusion?
We're done on this segment. Sorry, Ms. Thompson doesn't prohibit a witness from answering in